Mr. Crowe.
One point left over from yesterday, your Lordship asked in relation to Corine whether it was just a case where there were preemption provisions or whether there were disadvantageous valuation provisions as well. The answer is the former. There were just transfer preemption provisions. There was no disadvantageous valuation in relation to what was being triggered, and it was in that context that the judge said that a strict approach should be taken. If you want to check that point, I'll just give you the reference. I won't take you to it. It's in paragraph 21 of the judgment, where Lady Justice Arden summarises the contractual provisions, and that's in the authorities bundle, tab 15, page 397. Making that point just reminded me that I made a point yesterday without taking you to the contractual provision in our case, because I said in the course of submissions that the provision in this case was expropriatory and it imposed a disadvantageous valuation provision. Your Lordship and your Ladyship may be already alive to this, but the relevant provision is in the Shareholders Agreement, so core bundle, to page 254 behind tab 14. And clause 7.3 effectively reads across the transfer preemption provisions from clause 6 into the operation of the deemed transfer notice, except that, and then if we go to D on the next page, if the seller is deemed to have given a transfer notice as a result of clause 7.1d, the transfer price shall be restricted to a maximum of the lower of, and those words are then unnecessarily repeated, the subscription price paid in respect of each sale share, including any share premium, and the fair value of each such sale share. And fair value is dealt with in clause 8. So there is a sort of cap on the valuation where a deemed transfer notice is served. And for that reason also we urge that it is appropriate to adopt, if you are of the view that there is ambiguity and it needs to be resolved one way or the other, it should be resolved in a way that is most favourable to the shareholder who risks expropriation. As at close of play yesterday, I was getting towards the end of ground 2, discussing whether a repudiatory breach is capable of remedy within the meaning of this contractual arrangement. I had offered our submissions on why the concept of repudiation of a contract under the general law and the right that that gives to the innocent shareholder to accept the repudiation or affirm the contract is an entirely separate concept from the question that arises as a matter of contractual interpretation in our case as to whether or not any breach is capable of remedy. And we had gone through very briefly the relevant bits of Schuller and Whitman, Akichi, and so on. I had mentioned, without having to go back to, the cases where that approach was taken, the question being whether or not a contract, whether a breach could be made good for the future in a practical and non-technical sense, was the approach that was taken in Crane and Wittenborg and in Force India, and by analogy in the Consumer Credit Act case of Woodchester and Swain. What I had said in opening on ground 3 is that we had 3 points. I've therefore dealt with the first two, the separate concepts point and the test that is derived from the case law as to what capable of remedy means. The third point, just to finish with ground 2, the third point is to draw your attention to the indicators in the contractual language with which we are concerned in this case, which demonstrate in our submission that the judge's approach was correct. And there are 4 very short points on which we seek to rely to to dispel the suggestion that there is an equivalence between the concept of a material breach and a repudiatory breach, which is essentially what Melandri Friend's argument amounts to. And the four linguistic indicators in the contract are, first one, I don't think we need to go back to it for this. The first is that clause 7.1d applies where a shareholder commits a material or persistent breach of the contract. It does not say where a shareholder commits a non-repudiatory breach. If it had been intended to have that effect, it could easily, and in our submission, would have said so. As it is, the wording in the contract makes no distinction between repudiatory and non-repudiatory breaches. Second point is that by using the expression material or persistent breach, it is of necessity that clause 7.1d applies not to trivial, inconsequential breaches. It applies to serious, material, persistent breaches. That being the case, there is no logical reason for trying to exclude its application to repudiatory breaches, because that would leave one in the rather strange world that the clause doesn't apply to trivial breaches, doesn't apply to repudiatory breaches, but applies to some intermediate category. And there simply isn't anything in the wording to suggest that that is the correct interpretation. The third point is that any breach which is repudiatory is by definition going to be a material breach. And there is nothing in the language of clause 7.1d to suggest that a distinction is being drawn between different categories of material breach. And the fourth and final point is, in a sense, is to pick up on the logic of what was said in Schuler and Whitman and the other cases. The language here is capable of remedy. And as was said in Schuler, the ordinary meaning of the word remedy is to make something good for the future. And it connotes the practical test that we have seen. And that, in our submission, highlights the conceptual difference between the general law rules on repudiation, which confer a right that can't be taken away, and the practical approach that is mandated under clause 7.1d. So for those reasons, my lady and my lords, we submit that the judge's interpretation, the judge's approach in relation to this point of law was entirely correct, and ground 2 should be dismissed. Which brings us to ground 4, and that, you will recall, is the question of whether or not there is an estoppel by deed, or by contract, as to whether the appellant should be treated as the holder of 1,652A shares. And it may be convenient just to look very briefly at how the point is actually put in the grounds of appeal. So that's core bundle tab 2, page 15. And you'll see paragraph 4 of the grounds, the learned judge was wrong to hold that the doctrine of estoppel by deed did not operate so as to bind the parties to the fiction for the purposes of construing their obligations under the shareholders agreement, that the claimant was at all material times the holder of 1652A shares. So that's the point that my learned friend is advancing. We have two responses. The first is that the argument is irrelevant, and the second is that even on its own terms it's wrong. While we've got the core bundle out, it may also be convenient when dealing with irrelevance. We could look at paragraph 76 of Malone Friend's skeleton, which is tab 3, page 32. So, dealing with the irrelevance of this argument, if we look at what the argument actually is at paragraph 76, the obstacles identified in the 5 following subparagraphs already, so this is talking about paragraph 409 of the judgment below, all relates to the wider transaction. This causes the appellant to consider that the judge may, with respect, have misunderstood his case. His case was not that the appellant needed to be treated as actually holding his 1,652 shares for all purposes. It was merely that he must be treated as actually holding them for the purpose of construing the parties' obligations under the Shareholders Agreement, and in particular, 1, what constituted a material or persistent breach, 2, whether that was capable of remedy. So there are 2 grounds upon which it is suggested that this estoppel by contract is relevant. Whether the breach was material or persistent, and whether it was capable of remedy. With respect, that argument is entirely irrelevant in this court on both grounds. As regards the materiality or persistence of the breach in relation to the A shares, the judge held that it was persistent, and my client admitted it was material. My client has not sought to withdraw that concession and has not served a respondent's notice, inviting you to depart from the judge's view that the breach was persistent. So in this court, it is common ground that the breach was material and persistent. It is therefore entirely irrelevant for the appellant to try urging on you that there may have been additional reasons for the judge to reach the conclusion that he did anyway. As you would have seen, the second reason why the appellant says this may be relevant is to the question whether or not the breach in relation to the A shares was capable of remedy. That, in our submission, does not present a coherent argument either, because, as you will have seen from the judgment below, the reason why the judge held that the A shares breach was remediable is that the A shares that were wrongly allotted to Gwent could be, as a matter of company law, and were, as a matter of fact, returned to Newco, as we're calling it, held in treasury, and then sold to the appellant when he finally got round to paying for them. That is all covered. If you just want it for the note at this point, I'm sure you know it, but it's covered in the judgment below at paragraph 303 and paragraphs 455 to 459. We don't need to go to them. But that was the basis upon which the A shares breach was held to be remediable. There was a mechanism under the Companies Act which was followed, by which the shares could be returned to the company, held in treasury, and then sold to Mr. Kulkarni when he paid for them. In that context, it makes not the slightest difference whether one share, which it was always accepted Mr. Kulkarni held, or 1,652 shares had to be returned to the company. The remediability of the A shares breach depended not on the number of shares in question, but on the availability of the mechanism under the Companies Act for the return of the shares to the company and their onward sale to Mr. Kulkarni. So there is simply no logical basis upon which it can be suggested that any assumption that the appellant held 1,652 A shares as opposed to just one share could affect the answer to the question whether the A shares breach was remediable. And with respect, my learned friend has not advanced any argument to support that proposition. So that's irrelevance. The second answer we have in relation to ground 4 is that the judge was right in coming to the view that there is on this contract no estoppel. So far as the law is concerned, it may just be convenient to have the relevant passages in the judgment open, but there is no dispute about the judge's summary in this regard. So if we go in tab 7 of the core bundle to page 143, which is where this issue is addressed, and the propositions are simply these, starting at 398. First of all, it is common ground that an estoppel by deed or by contract arises where the parties to the contract intend that a statement of fact in the contract is to be treated as true, regardless of whether it is in fact true. That is what one gets from the PK, and there's no doubt that that's the correct summary of the law. Secondly, the question is accordingly whether, as a matter of construction, the relevant recital amounts to a mutual agreement to treat the statement as true, irrespective of its falsity. And you'll see question of construction is a phrase used in the quote in paragraph 400 of this judgment, quoting Greer and Kettle, and also in the passage quoted in paragraph 401 of the judgment below from Prime Site and Lavarello. It's a question of the construction of the agreement itself. And you were taken yesterday to Reeve and McDonough. I don't need to take you back to that, which makes the same point. And so the correct approach, and this is paragraph 402, the correct approach is to construe the relevant contract, the shareholders' agreement in this case, within the wider context of the overall scheme of which it formed part. So that's the legal framework. It's helpful, I think, just to pause for a moment to understand what the case was, the pleaded case was, at trial. If we could just go in tab 10 to the re-amended particulars of claim, and if we could turn up page 191, the estoppel by deed heading, you'll see a third of the way down the page. It's, I think, sufficient just to look at paragraph 41 to see what the pleaded case was. Under the doctrine of estoppel by deed, just as Newey and the claimant are bound by the statements of fact in recital A and recital B, that Gwent is the registered owner of 1,718 fully paid A shares, so Newey and Gwent are bound by the statements of recital A and recital B that the claimant is the registered owner of 1,652 fully paid A shares as at 13th February 2020. This was part of Mr. Kulkarni's case that he didn't have to pay for his shares. Now he's rowed back from that in this court, and he's saying, oh, well, there's an estoppel by contract in relation to recital B which says I've got the shares. But there's no estoppel by contract in relation to recital A, which says I've paid for them. That, in our submission, is an incoherence, because it suggests a sort of a la carte approach to whether or not contractual recitals give rise to an estoppel. There's no coherent basis upon which Melenda Friend can advance what is a less obviously wrong argument. That the estoppel arises in relation to the holding of the shares, but not in relation to the question of whether they were paid for. So we just wanted to emphasise that what is, and it's one reason why I took you to ground 4, is that it is different from what the pleaded case actually is. It's obviously a matter for you whether it's open to Melenda Friend to advance a case that is not in fact his pleaded case. But insofar as you do indulge him by allowing him to run at that point, it is, as we submit, relevant to note that there is this internal inconsistency, and there's no principled basis upon which he has suggested that recital B gives rise to an estoppel, whereas he accepts that it would be hopeless to suggest that recital A does. It's also relevant, and it's the other reason I took you very briefly to ground 4 in the grounds of appeal. It's also relevant to note that there isn't, so far as we are aware, any authority for proposing that an estoppel by contract can arise for one purpose, but not for another. You will recall that the wording in ground 4 is that the parties are bound for the purposes of construing their obligations under the shareholders' agreement. They don't seem to be being bound for any other reason. And in our submission, that is a novel proposition, that there's this sort of, not only the a la carte approach to which recitals give rise to an estoppel, but there seems to be a selective operation of the estoppel only in relation to questions of contractual interpretation. With that, by way of preliminary introduction, if we just briefly go back to the judgment, as you will recall, the judge dealt with this having recited the law, so if we're back in core bundle at page 144, and he dealt with the language of the recital, paragraphs 405 to 408, and essentially just said, well, yes, recital B says what recital B says. The question then is, construing the contract in the context that was known to the parties, was it intended to represent, as the authorities say, a mutual agreement, an agreement to treat the statement as true, irrespective of its falsity? And what the judge then does in paragraphs 409, subparagraphs 1 through to 5, is to identify the contextual points that indicate that that was not a mutual agreement. Now, my learned friend's complaint is, and I read this to you very briefly a few moments ago in paragraph 76 of his skeleton argument. His complaint is that all these points relate to the wider transaction, as he says. Well, that, with respect, is just a fancy way of saying that the judge was taking into account the context that was known to the parties and the very purpose for which the Newco was being established after the economic failure of Old Co. The Newco needed money. The suggestion that the parties were agreeing that Mr. Kulkarni should be treated as getting shares not only priced at a discount but not even having to pay the discounted price was, with respect, a hopeless line of argument. And the judge, with respect, was fully entitled, indeed required, to take into account the wider context. Second point under this heading is that it is not, in fact, true to say that all the sub-paragraphs of 409 in the judgment are merely contextual points. 409.3 specifically relates to the fact that the B shareholders were to become parties to the shareholders' agreement through deeds of adherence. Given that the estoppel is a matter of contractual construction, not reliance, upon doing so, they would also be bound by any estoppel. It would be, in my view, a remarkable conclusion to say that they contracted on the basis that they had put in capital, which they were required to do under the articles, but the A shareholders did not. And that is not just a contextual point, it is based on the terms of the shareholders' agreement under which B shareholders could join. So in our submission, it is simply the position under ground 4 that the argument actually goes nowhere, but the argument is wrong. Ground 5. Ground 5, and again, it's helpful, I think, just to remind ourselves of exactly what the point is. My learned friend dealt with 5, 6, and 7 to some extent compendiously, but it is important to take a slightly rigorous approach in identifying what the point is. So if we could go back to the grounds of appeal, core bundle tab 2, at page 16. The learned judge, paragraph 5, the learned judge was also wrong to exclude from consideration of the construction of the shareholders' agreement, and thus from the concept of remediability, the pre-existing relationship between the parties, and in particular the claimant and Mr. David Lewis, the shadow director and ultimate beneficial owner of the first defendant, and Mrs. Jane Lewis, the director. So what is being said is that the judge was wrong to exclude from consideration the prior personal social relationship between those three individuals. And we have two answers to that line of argument. The first is that it's wrong. The judge did not exclude from consideration the prior personal social relationship. He took it very fully into account, but he decided that it did not affect the legal analysis of the claim as pleaded. And I'll expand both of these points, but I'll just identify them. So the first answer is that the complaint is misconceived. The judge didn't exclude from consideration the pre-existing relationship. The second point is that the judge was entirely right in reaching the conclusion that the pre-existing relationship was irrelevant to the legal analysis, and it was irrelevant both to the interpretation of the shareholders' agreement and to the question whether or not any breach was remediable. So on that very first point, I can deal. The first point is the judge did not exclude from consideration the pre-existing relations. He dealt with them at length, and I'm not going to go through it, just for your note. It's paragraphs 436 to 447 of the judgment. 436 to 447, he deals at length and explains why the prior social relationship is irrelevant to the legal analysis. And for good measure, we haven't actually had occasion to look at the judgment he gave dealing with consequentials, most of which deals with costs, but he also deals with the application for permission to appeal. And it's convenient just to see what the judge himself had to say about this. So if we just glance briefly in the core bundle, tab 8, at page 176, you'll see right at the bottom of 176, fifth, it is said that I was wrong to exclude from consideration of the construction of the shareholders' agreement, and so from the concept of remediability, the pre-existing relationship between the parties, in particular between Mr. Kulkarni and Mr. David Lewis. I did not exclude the relationship between Mr. Kulkarni and Mr. Lewis from consideration. The reasons I gave at, for example, and then he lists a number of paragraphs, I specifically addressed the role that the pre-existing relationship played and found that Mr. Lewis acted as a commercial party in the course of negotiations, and that this was obvious to others, most notably Mr. Davis, and that it should have been obvious to Mr. Kulkarni, not least because Mr. Davis told him as much. So one has it there from the trial judge himself. In a sense, it's merely a comment on his own judgment, and the same conclusion can be reached by reading his judgment. But it's helpful just to see the unequivocal terms in which the judge rejected that suggestion. The second point, then, under this heading, is we say that the judge was entirely right to reach the conclusion that the prior social relations between Mr. Kulkarni and Mr. David Lewis and Mrs. Jane Lewis were irrelevant to the legal analysis. Just by way of preliminary introduction, so that you are not unaware of this, the first preliminary point is that the relationships on which the appellant seeks to rely in this court are, in fact, again, different from the relationships in his pleaded case. So just so that you've got the point, if we just very briefly go back to the re-amended particulars of claim, so that's tab 10, And if we look briefly at paragraph 90, which is on page 202, possibly in your version. Sorry, I've been giving my page numbers. So 202, you'll see that the pleading relies on the prior relationship between the appellant, Mr. David Lewis, Mr. Andrew Lewis, Gwent, and Newco. Whereas, as we have seen, ground 5 of the appeal seeks to rely on the prior relations between Mr. Kulkarni and Mr. David Lewis and his wife. Flowing on from that, there was no pre-existing relationship between the appellant and Andrew Lewis. That is dealt with in the judgment on permission to appeal. I don't propose to take you back to it, but it's addressed in the judgment on permission to appeal, paragraph 45, which is page 177. The relationship, secondly, the relationship between the appellant and Mrs. Lewis was entirely irrelevant to the issues at trial. That's addressed again in the judgment on permission to appeal, paragraph 45. So one is then left by way of analysis only with the suggestion under ground 5 that the prior social relationship between Mr. Kulkarni and Mr. David Lewis is somehow irrelevant to the outcome of the legal analysis. So far as that is concerned, the first point is, and it's the reason I perhaps overemphasized when reading ground 5, the word parties. You may remember that the wording of ground 5 is the learned judge was wrong to exclude from consideration the pre-existing relationship between the parties. Mr. David Lewis is not a party to the Shareholders Agreement. The suggestion that the interpretation of a contract should in some indeterminate way be affected by pre-existing social relationships between individuals who were not parties is, in my submission, unorthodox. Second point, as to why the judge was absolutely right, is that the pleaded claim he was addressing, and the judge made this point a couple of times, he's just dealing with the issue that's brought in front of him. He can't solve things. He's just resolving the pleaded claim. The pleaded claim was expressly not on the basis of a quasi-partnership. My learned friend accepts as much in his skeleton argument in this court, paragraph 83, and although I don't need to take you to it, he expressly made the point in opening at trial that it was not a claim based on a quasi-partnership relationship. That was in the trial opening, which is, I don't need to go to it, but it's in the supplemental bundle at page, tab 80, page 346. The claim was always and only about whether or not there had been a breach of the express terms of the written contract. The prior social relationship between the parties was, to that extent, an irrelevance. The third point is that, as the judge made clear in his judgment, paragraph 440, the contractual terms are arm's length. This is not a contractual joint venture in the sense of mutual trust and confidence, express terms of good faith, and so on. And the judge identifies in paragraph 440 of his judgment the express provisions in the contract. We don't need to go through them, but you will see them. They are drag-along rights, the possibility of others becoming B shareholders, the fact that Gwent had board control under clause 14.5, the entire agreement clause, and the no partnership clause. All of those are entirely clear in making apparent that the nature of the contractual relationship was expressly and exclusively an arm's length commercial arrangement. And the fourth point is that, as the judge also points out in paragraph 442, there was no contractual term. He says that those are the terms that were in the contract. The next point, what wasn't in the contract was any express term imposing a duty of trust and confidence. Now, I'm not suggesting for one moment that that is always necessary in order for a relationship to be treated as being purely contractual and interpreted as such, but its absence is a relevant factor, and it is a point the judge was fully entitled to take into account. The fifth point under this heading is that on the facts, the contract was negotiated at arm's length, self-interest on both sides, which is the point the judge makes in some detail at paragraphs 443 to 446 of the judgment. So the overall conclusion is that the business relationship between the parties under the shareholders' agreement was commercial in nature. It was governed by the express contractual provisions, and the fact that various breaches may have impacted on the personal relations that previously existed, the previously cordial personal relations between Mr. Kulkarni and the Lewises. It is unfortunately collateral damage from the breakdown of a business relationship. The fact of the prior social relations is an irrelevance to the question of contractual interpretation. And the final point really under this heading is that with respect, my learned friend has offered no coherent explanation of how the prior social relationship could actually affect the interpretation of the contract. In what respect? Which term, is it said, could be interpreted differently because the court knows that Mr. Kulkarni used to get on with David Lewis? Equally, no coherent argument has been advanced as to why the pre-existing social relationship can affect the question of remediability. The remediability of the contract doesn't require the social relationship to be put back together. The contract is a business relationship, and the fact that there was a previously harmonious social relationship between the parties doesn't affect the answer to the question whether the breaches were remediable, because as we've seen, the A shares breach, and for that matter the B shares breach, were remediable because of the mechanism that's available under the Companies Act for the shares to be returned to the company, to be held in treasury and then sold to Mr. Kulkarni when he gets around to paying for them. None of that would be any different by way of analysis or any more difficult, simply because there had previously been a social relationship between the parties. Similarly, the Hussein breach was remediable because Mr. Hussein's appointment as a director could be accepted, albeit belatedly as it was accepted, and again, doesn't make it harder for that to happen simply because there was a prior social relationship. And so far as the termination breach is concerned, as we will see when we get on to deal with ground 6, nothing needed to be remedied there because it is common ground that the appellant never accepted the repudiation and the contract continued in existence, so there was nothing to remedy. So ground 5 in our submission is wrong on both grounds. The premise is wrong. The judge did not exclude the social relationship from consideration, and it's wrong in its legal argument because the judge was in fact entirely correct to reach the conclusion that the prior social relationship is irrelevant to the question of the interpretation of the contract and the question whether any breach was remediable. Which brings us to ground 6, And ground 6, as you know, is the question whether the judge was correct in holding that the various breaches were remediable. The first point we want to make under this heading, I've already foreshadowed, which is the applicable test on appeal. So just working through the analysis, as we have seen, the test for determining whether any given breach of contract is remediable is whether it can be put right for the future in a practical and non-technical sense. That is either a question of fact or a question of evaluative judgment, probably a bit of both. But whatever it is not a question of law on which there is a right and a wrong answer. And that, we submit, is a relevant factor in this court, because you are not reaching a de novo decision on whether you, if you had been the trial judge, would have thought that these breaches were all remediable. You are hearing an appeal against a factual finding and or an evaluative judgment by the judge. And the appellant accepts that the judge applied the right legal test. So if we can go to paragraph 91 of his skeleton, page 36 in the core bundle. So, albeit with not great enthusiasm, my learned friend says in the first two lines of paragraph 91, the appellant does not dispute that the judge had regard to the principal authorities, nor does the appellant particularly dissent from the principles the judge extracted from them in paragraph 435. He then goes on to make one qualification, which is essentially ground 5. He says the judge was wrong in not taking into account the prior social relations. In our submission, we've already dealt with ground 5, so that qualification to the appellant's acceptance that the judge had in mind and applied the right authorities, that exception is an exception with no content. So we do proceed in this appeal on the basis that the judge applied the correct legal test. And it is trite, I'm sure it's said in every case in front of you, that the judge had the advantage of considering the whole universe of the evidence at trial, which obviously you don't. So that being the nature of the decision that the judge took, in this court, you can plainly only interfere with the finding of primary fact on the well-established grounds, and equally, you can only interfere with matters of evaluative judgment on equally well-established grounds if the judge's view was one that was outside the bounds within which reasonable differences of judgment can be formed. As it happens, we will say that the judge was absolutely right in his assessment of whether these breaches were remediable. But we only have to say that he is not obviously wrong, because that's the test in this court. And it would appear, with respect, that the appellant is not actually saying that the judge was obviously wrong. It'll be a recurrent theme in our response under ground 6. That the appellant is essentially addressing you as if you're the trial judge. He's just running his arguments. He doesn't face up to the test, the threshold test on appeal. If we just look, there's one of the best examples is paragraph 95, at the top of page 37, where the appellant says this approach takes the practical approach advocated by Lord Justice Neuberger in Akichi too far. Well, Actually, that's simply a way of saying the judge has in fact applied the right test, but he's come to an answer that the appellant doesn't like. He doesn't say it's outside the bounds within which reasonable differences of opinion can be formed. And he repeatedly doesn't face up to the threshold test that he has to meet in this case. There is reliance on Phoenix Media in Maloney and Friends Skeleton, paragraph 96.1. I don't think Malone and Friend really developed any argument by reference to that, and all we would observe in relation to Phoenix Media is, as Malone and Friend entirely fairly pointed out, that the contract in that case did include an express term requiring good faith dealings, and that term was expressly referenced when the judge was dealing with the question of materiality and remediability in paragraph 60. But in any event, it doesn't really assist this court on appeal to sort of pick illustrative examples of other factual situations in which the court, a trial court, has had to address a similar question. What matters is whether this judge on these facts came to an obviously wrong answer. Similarly, Malone Friend just also mentioned the Wickland and Telchatter case, the mobile homes case, and he particularly picks up in his skeleton, and again this wasn't really developed orally, but just for reference as it's not unanswered. Malone Friend's skeleton, paragraph 96.2, he cites the bit in Lord Wilson's judgment where Lord Wilson speculates about the possibility that there might have been a different outcome if the individual had not only jumped out wearing camouflage and a balaclava, but had actually inflicted serious injury. And he said, well, that might have constituted an irremediable breach. That doesn't really get one anywhere. It's obiter musing on entirely different facts, which involved a completely different contractual arrangement. The judge was not, in fact, dealing with the point that Malone Friend wants to get from it, which is the question of motive. We're not talking here about physical injury. We're talking about the question whether the motives, the alleged motives with which the breaches were committed, has any relevance. The other preliminary point, just before we get on to the individual breaches, the other preliminary point I just wanted to make is a counterblast to some of what is in the skeleton, although again it wasn't really developed orally by Malone Friend. Malone Friend's skeleton contains quite a lot by way of highlighting aspects of the story which he obviously considers reflect badly on Andrew or David Lewis. That's paragraphs 98 to 103 of his skeleton argument. We just wanted, so that it's not lost, we just wanted to emphasize that it is not open to the appellant in this court to try going behind the following few key factual findings of primary fact by the judge. I just wanted to enumerate them. First, the judge expressly found that the appellant could not honestly have believed that he had a binding agreement to get his shares for free. Could not honestly have believed that he had a binding agreement to get his shares for free. That's paragraphs 125 and 128 of the judgment. Secondly, and as a sort of corollary to that, the judge found that the appellant was stalling for time in not resolving the question of his obligation to pay for the shares in the hope that David Lewis would bail him out. And that is illustrated by paragraph 181 of the judgment. Third, the judge found that Andrew Lewis was justifiably frustrated by the appellant's stalling, and that Andrew Lewis was rightly trying to clarify the position. There's a string of paragraphs in the judgment. If I could just give you the paragraph numbers without asking you to go to them now. So 187 to 188, 214, 224, 280, and 281, where the judge refers to the appellant's constant evasion and prevarication.
And just to understand how this fits in, you're making these points in response to criticisms of the two Mr. Lewises.
Yes. And the relevance of it is that as part of the sort of the mood music with which the appellant is trying to invite you to address the question of whether the judge was right on remediability, is to emphasise misconduct on not my client's part, on the part of the individuals, principally Mr. Andrew Lewis, and this is our counterblast to that, just to sort of rebalance the mood music, essentially.
Yes, I see.
Fourth point, very brief, there are only two more. Fourth point, the judge found that Andrew Lewis's handling of the matter displayed, in the judge's words, poor management and judgment, but not personal animus. That's paragraph 283. And the corollary to that, the fifth and final point, is that the judge rejected the appellant's case that there was a long and sustained attempt to misappropriate the appellant's shareholding. I say that because that phrase, a long and sustained attempt to misappropriate the appellant's shareholding, is in the appellant's skeleton in this court. He says that that is the basis upon which the question of remediability should be addressed. It's paragraph 110 of the appellant's skeleton. The trial judge expressly rejected that allegation. And the relevant paragraphs, I won't read out all the paragraph numbers because they are in fact in our skeleton, they're referenced in our skeleton, paragraph 57.1. I would merely emphasise, in particular, paragraph 249 of the judgment. There was no plan from the outset to remove the appellant. And 282 to 283, where the judge refers to decisions being taken on the basis of a business view. And again, just because it's had little airtime, in the judgment refusing permission to appeal, paragraph 47, which is core bundle tab 8, page 178, I suspect in your version, the judge says in terms, I found as a matter of fact there was no animus, just the breakdown of a business relationship. And Melanfrand has sought to argue that motive is relevant to remediability, and he can't. He can't make that case in this court because his allegation of bad motive, of malice, which was the word used in the pleading, is expressly rejected. So the question of remediability has to be decided on the basis of the findings of primary fact by the trial judge, that there was no animus, there was just a breakdown of a business relationship. So, just addressing the points that my learned friend has made, that was all the sort of the introductory stuff. Addressing the first point my learned friend seeks to make, he says that the judge didn't take into account his own findings of fact as to the gravity of the breaches when assessing whether they were remediable. That's paragraph 93 of his skeleton. He says the judge didn't take into account his own findings of fact as to gravity when assessing remediability. We would make a number of very short points in response. The first is that it is, as a matter of principle, an odd line of argument to try advancing, because all of the matters which the appellant says weren't taken into account are in fact expressly contained in the judgment. paragraph 93 of Mullane and Friends Skeleton. The Mullane and Friends Skeleton lists in paragraphs 26 and 27, and in paragraphs 99 to 101. So those are the paragraphs in Mullane and Friends Skeleton, which lists the factual findings that the judge made. It is, as I say, with respect, an odd line of argument to suggest that the judge didn't take into account the very findings that he himself had made. And it's even more peculiar because the argument is even more peculiar because the judge expressly recognized that the gravity of a breach is relevant to the question of whether it's remediable. He quoted the relevant case law in paragraph 429 of his judgment. We don't need to go to that particularly. Paragraph 429 on page 149. And he specifically included the point that the gravity of a breach is relevant to the question of remediability. When having gone through all the case law, he then, in paragraph 435, he captures the approach in 4 summary propositions, the third of which is the more serious the breach, the harder it will be to remedy, as even material breaches are remediable. So to suggest that the judge, when applying the test he had correctly himself laid down, he forgot the facts which he himself had found in our submission is just an incoherent line of argument. If what my learned friend wants is the judge actually somewhere in his judgment actually to say, and I am applying the test I have already laid down and I am taking into account the facts I've already recited, that would be a sort of a formulaic approach to a judgment which this court does not mandate. The other point that we just want to make before turning to the specific breaches is that there is, with respect, no principled basis upon which this court, as an appellate court, can say that a judge has given insufficient weight to the gravity of the breaches. There's no mathematical formula, so to speak, for saying, well, the judge gave it this much weight and he should have given it this much weight, and which is really just another way of saying that this is an appeal in relation to an evaluative judgment, and there's no objective basis upon which it can sensibly be said that the only conclusion the judge could reasonably have come to is that these breaches were irremediable. So that, by way of preface, I can then turn and go through the individual breaches relatively lightly, because to some extent we've already anticipated why they were remediable. The A shares breach, as I had said, was found to be remediable because the shares wrongly allotted to Gwent could be and were returned to Newco, held in Treasury, and ultimately sold to the appellant. That is, and I think I've already given you the paragraph numbers in the judgment below. That's paragraph 303, which describes the history, and 455 to 459, which deals with those facts in the context of remediability. That sequence, returning the shares, holding the Treasury, selling them on, plainly put matters right for the future in a practical and non-technical sense. And in fairness, I don't think the appellant actually disputes that. His only argument under this heading is to say that the A shares breach could not have been remedied within 10 business days. That's the point he makes in paragraph 105 of his skeleton. So the argument is not that, as a matter of principle, the wrongful allotment to Gwent couldn't be remedied. The argument is it couldn't be remedied within 10 business days. To which the first answer is that that is an illegitimate line of argument for the appellant in this court, because it is in fact a disguised attempt to reverse a factual finding of the judge. The judge accepted, we will need to go back to the judgment for this, so if we just go in the core bundle at your page 153, paragraph 448. Right at the bottom of the page, Mr. Butler further submitted that the time period of 10 business days within which remediation was to be achieved is relevant to assessing whether a breach is remediable. Something that would take longer than 10 business days to remedy could not be considered remediable for the purposes of 7.1d. It seems to me that as a matter of simple logic, that must be correct. So, irrespective of whether the judge was right on that, and it may or may not matter, but we have our doubts. But anyway, let's accept that that's right. The judge is accepting the appellant's submission as a matter of principle. Having made that finding, he then says at paragraph 455, bottom of the same page, the test is a practical one. Could the breach be put right for the future? And so the practicalities are significant. He doesn't say they're determinative and the only thing he's taking into account. Here, as a practical matter, it plainly was straightforward to reverse the allotment and issue of both the A and B shares. And he repeats the point when he gets to the end of this section at paragraph 459 over the page. Both as a matter of practicality and as a matter of principle, in my view, the A and B share breaches were remediable. So having accepted the appellant's proposition that a breach that would take longer than 10 business days could not be considered to be remediable within 7.1d, the judge reaches the conclusion that it was plainly straightforward to reverse the allotment. So he's making a finding on the assumption that this is something that would have to take place within a 10-day window. And he's made that finding a fact. There's no basis upon which, in an appeal court, this appellant can say, well, he shouldn't have reached that conclusion.
Could it have been done in 10 days?
Sorry?
Could it have been done in 10 days?
Well, one's got to keep in mind, yes. Part of the answer is one's got to keep in mind what the breach was. The breach was the wrongful allotment.
Yes.
The fact that it took another 9 months or something for Mr. Kulkarni to agree that he had to pay unconditionally is not the point, because the breach that's pleaded and found is the allotment. All that needed was a return of the shares. And the sequence, in fact, I think the chronology Melanie friend mentioned, but the chronology is set out in paragraph 303. So if...
Sorry, 303 or 303?
Of the 303 of the judgment. If one treats the letter from Newey as a sort of, simulacrum for a remediation notice, that letter from Newey's solicitors was the 24th of September 2021. Gwent agreed to that 3 days later on the 27th, and the necessary resolution was passed 2 days after that on the 29th. The process by which the shares then got sold to Mr. Kulkarni when he finally agreed he had to pay unconditionally is not part of remediating the breach. So the judge made a finding of fact, and it's a finding of fact which, on the chronology, he was absolutely entitled to make.
And just remind me, there was some reference, wasn't there, to the stamp duty position. How did that work?
There has been reference to that, and I'm not sure, to be honest, that the full factual position in relation to that is in the bundle, so I can't give you a complete answer. But in our submission, the material that's in front of you and the material that's in front of the judge entirely justifies him in reaching that conclusion. But the second point, the second part of my answer to your Lordship's question, is that it is in fact wrong in principle to approach the question whether the breach could have been remedied within 10 business days by looking at what in fact happened when no remediation notice was served. And if a remediation notice is served and the clock is ticking, one might expect people to get on with things a little bit quicker. No remediation notice was served in this case, so it's just a sort of a false approach to say, yes, I mean, it took a month to get the stamp duty sorted, and therefore we decided as a matter of principle it could not have been done within 10 days. And the other point is that to suggest that the remediation has to be started and finished within 10 days is in fact predicated on my learned friend's interpretation of 7.1d, because his argument is the clock for providing remediation only starts ticking when the 10-day notice is served. There's no reason to assume that remediation might not be started significantly before that. So it is entirely possible that preliminary steps could be being taken before the clock actually starts running. So for those two reasons, it is, in our submission, just wrong in principle to try reaching an assumption as to whether the breach could have been remedied within 10 days by reference to what did in fact happen in the absence of a remediation notice. That is all we wanted to say on the remediability of the A shares breach. The B shares breach raises no separate point, save this. My learned friend's skeleton and his oral submissions, I don't ask you to go to it, but it's para 108 of his skeleton, and his oral submissions yesterday referred to the fact that B shares were also allotted to certain other consultants. And you may have been left with the impression that the allotment of B shares to the other consultants formed part of the necessary, reversing that allotment to the other consultants, formed part of the necessary remediation of the B shares breach. That, with respect, is wrong. It's manifestly wrong on the basis of the pleaded case and of the judgment, because the pleaded case is that the B shares breach was the wrongful allotment to Gwent of 2,000 B shares. There is no breach of the shareholders agreement alleged in relation to allotting B shares to the other consultants. The B shares breach is only the allotment to Gwent of the 2,000 B shares, and that is apparent from the re-amended particulars of claim. We probably don't need to go to it, but can I just give you the references? So, re-amended particulars of claim, paragraphs 60 to 62, which is core bundle, tab 10, page 194. The B shares breach is then expressly referred, entirely correctly and inevitably described in the first instance in the judgment below, paragraph 2.2, as being referable to the allotment to Gwent of the 2,000 B shares. And in fairness to my learned friend, although there was some deviation from this in his oral submissions, in his skeleton argument, he quite rightly identifies in paragraph 27.2 of his skeleton argument in this court, he identifies the B shares breach as being Gwent additionally procured that Newco would allot to it 2,000 B shares without offering the appellant the opportunity to subscribe for any. So the B shares breach is and is only that allotment to Gwent. The fact that B shares also happened to have been allotted to other consultants does not form part of the B shares breach and therefore does not need to be remedied. And the question of remediability of that, the question of whether those allotments could have been reversed is an irrelevance. Third breach, termination breach. The appellants say that the termination breach was irremediable. That's paragraphs 109 to 110 of his skeleton in this court. But just three very short points in response. The first is he does not seek to challenge the judge's finding that, in the words of the judge, the termination breach did nothing at all. That's paragraph 462 of the judgment below. 462. The termination breach did nothing at all. And indeed, on his feet yesterday, my learned friend, I think, used the phrase, it didn't have any impact. So if something did nothing at all and didn't have any impact, it is, with respect, impossible in this court to suggest that the judge was obviously wrong to reach the conclusion that that breach was remediable. Secondly, in a sense it's all part of the same continuum, Malone and Friend does not engage with the threshold test which he needs to satisfy in order to succeed on an appeal. He simply, in this passage of his skeleton and in his oral submissions, has repeated arguments he made in the court below and which have failed, and there's no basis upon which this court can reach the conclusion that the judge below was obviously wrong. And we do say that, thirdly, the judge was not only not obviously wrong, he was unarguably correct, because the appellant on his own case never accepted the repudiation.
Logically, there's nothing that could have been done. Logically, there's nothing that could have been done after the termination breach. The only thing left is for Mr. Kulkarni to decide whether he's had enough and go, or say, no, we keep going a bit longer.
Exactly. Finally, the Hussein breach. Again, Malone and Friend says, by reference to the arguments he ran in the court below, that the breach is irremediable. We make essentially the same points again. First, there's no attempt by him to satisfy the relevant appellate test. Secondly, as it happens, we say the judge was absolutely right, or at least he was not obviously wrong. The delay in accepting the appointment of Mr. Hussein as a director was in exactly the same category as the failure to conduct periodic visits, which was the subject of the discussion in Schuler and Wickman. The fact that the delay could not be undone doesn't mean that the matter could not be put right for the future, and that was the test that should be applied. Malone and Friend has tried drawing an analogy with the disclosure of confidential information, but that, with respect, is just a false analogy. The reason why the disclosure of confidential information is irreversible is that once it's out, it's out. The damage is done. The breach is, promising not to do it again, not to commit another breach, doesn't make good for the future. The breach that has already occurred in relation to this disclosure of confidential information. Whereas resuming periodic visits in Schuler and Wickman, or accepting the appointment of Mr. Hussein as a director in our case, clearly does make things good for the future. And the final point that the judge makes in paragraph 465 of his judgment is that on the facts of this case, the breach made no practical difference. The appellant has not identified any specific information which he says he would have wished to see any sooner. And as the judge mentions, the fact that Gwent had board control under clause 14.5 of the Shareholders Agreement means that even if Mr. Hussein had participated in board meetings, he would not have been able to override anything that Gwent wished to achieve. So for those three reasons, we submit that the Hussein breach was remediable, but all we have to submit is that the judge was not obviously wrong in reaching the conclusion that it was remediable. So for those reasons, we submit that the appeal on ground 6 should be dismissed, which leaves us with ground 7. And the argument here is that the breaches may not have been irremediable when first made, but as a result of the passage of time, they became irremediable. The answers now can be given relatively rapidly because they essentially involve a certain amount of repackaging of points that have already been made. The first is that the appellant is, under this heading, seeking simply to rerun arguments that he made in the court below, and he is inviting you, although he doesn't face up to the threshold test, he is inviting you to overturn an evaluative judgment made by the court below, and in our submission there is no basis for doing so. Secondly, and in a sense as part of maybe point 1b, there is no coherent basis for saying that it became any harder to remedy the breaches because of the delay. 1 day, 2 days, 5 days. What's the difference? Actually, there is just no substance to the point. Third point, the appellant's argument at trial, and it's important just to understand the context in which these points arise. The appellant's argument at trial was that the length of time for which the breaches persisted was relevant because of the damage it caused to the personal relations between him and the Lewises. That is apparent from the first instance judgment at paragraph 468. So we are in fact looping back into ground 5. The reason why delay was said to be relevant is that it was damaging to the personal relations, but that is an irrelevance in the context of a business relationship that was founded on an express contract negotiated at arm's length. Fourth point, the appellant says that the judge made an error of law by treating motive as relevant only to the question whether there was repudiation and ignoring it when it comes to the question of deciding on remediability. And that is the argument. This is why we went, I think, to Swiss Atlantique. So that's, for your notes, that's paragraphs 118 to 121 of my learned friend's skeleton. So he says here, there is an error of law in the judgment below by treating motive as relevant only to the question whether there's repudiation and ignoring it when it comes to remediability. To which we have two answers. The first is that there is in fact no error of law. Swiss Atlantique says what it says, and the judge's quotes in paragraphs, he deals with this between 467 and 473. The judge was entirely entitled to take the approach he did as a matter of law, based on Swiss Atlantique, which of course is House of Lords, my learned friend's reliance on Phoenix Media to say that motive is relevant to remediability doesn't do him much good, bearing in mind Phoenix Media is first instance and Swiss Atlantique is House of Lords. But there is an entirely independent second point, which is that the appellant's argument goes nowhere because on the judge's findings of primary fact, he had rejected the case that Gwent was motivated by malice. There was no bad motive to take into account in any event. So even if the point of law were correct, in fact it goes nowhere because there was no bad motive for the judge to take into account. And the final point under this, no, the penultimate point under this heading is that many of the matters upon which the appellant sought to rely at trial, in fact post-dated the issue of the proceedings, and as such cannot be relevant to the question of whether the breaches themselves were remediable. That's a point covered in paragraphs 483 to 500, 483 to 500 of the judgment. It can't be relevant to the question of remediability because even on the appellant's own case, and this is paragraph 120 of the appellant's skeleton, he says, regard must always be had to the motive underpinning the breach. So pointing at things that happened after the breaches and indeed after proceedings were issued is irrelevant. And the final point under ground 7 is that the appellant never asked the board of Newco to serve a remediation notice, which would have started a clock ticking for remediation. Since he didn't try operating the contractual provisions, it's difficult to see how he can say that the persistence of the breach turned otherwise remediable breaches into irremediable breaches because there was a contractual solution available, and he did not try encouraging the board to operate that provision. So for those reasons, we submit that ground 7 is also to be dismissed. And if I can turn briefly to see if I've missed anything. Those are our submissions, unless there are questions from the bench.
No, I don't detect any more questions, so thank you very much, Mr. Crowe. Mr. Butler.
My lords, my lady, I want just to make a few points in reply in relation to each of the grounds in turn. Starting with ground 1, in relation to the argument that clause 7.1d on my learned friend's construction is rendered toothless, I'm content to take my stand on the matters in my skeleton argument at paragraphs 48 to 55. One of the points I made there is that as regards a section 994 petition, and I'm sure the court is aware that this is trite law, one's first point of reference is the terms of the shareholders agreement between the parties. There's authority for that in the bundle, which I didn't take your lordships and your ladyships to in my oral submissions. It's the Saul D. Harrison case referred to at paragraph 53.2 of my skeleton, but for the court's note, that's at page 127 of the authorities bundle with the relevant passage at page 140. I also gratefully adopt my Lord Justice Newey's point, which I probably should have made when on my feet, that there is an obvious point of distinction in that the other cases are two-party situations, whereas this unusually is a three-party situation, and the inability of the innocent shareholder to control the process is a significant factor which justifies a different approach to clause 7.1d in the present case. The only other thing I want to say on ground 1 is in relation to the authority of Coroyn. Now, if I can just ask the court to go to Coroyn, it's actually helpful to me in a couple of respect. It is page 389 of the authority bundle. The facts are of some complexity, but the dynamics were not, in fact, unlike those in this case. There was a shareholders agreement which contained certain provisions which would facilitate the acquisition of one shareholder's interest by another shareholder. And one of those circumstances was where the shareholder's shareholding was charged and that charge became enforceable. Now, what seems to have happened on the facts is that the shareholder who ran into financial difficulties created a security, but did so in such a way as to sail just within what was considered acceptable under the shareholders agreement. And so, in fact, when the innocent shareholder brought a section 994 petition, that failed, both at first instance and on appeal, precisely because what had happened was just within the acceptability created by the shareholders agreement, following the approach in the Saul D. Harrison case. Now, the other thing that you need to be aware of in considering Coroyn is that Lady Justice Arden was, in fact, in a minority on the question of the meaning of the relevant clause. The dicta that my learned friend relied on are at page 404 of the authorities bundle. That's paragraph 65.
Sorry, paragraph 65. Yeah.
And in particular, paragraph 67. But it is important for the court to keep in mind that the other members of the court disagreed with Lady Justice Arden on the question of whether clause 662 was triggered. The references are paragraph 146 in the judgment of Lord Justice Morbick. That's at page 418.
Sorry, that was Lord Justice Morbick.
Morbick.
At.
Paragraph 146, page 418. And finally, Lord Justice Reimer, paragraph 177, which the court will find on page 424 of the authorities bundle, agrees with Lord Justice Morbick. Now, that's not to say that they said that Lady Justice Arden had got the law wrong. I want to be clear about that. But it does show the dangers of taking this approach to interpretation too far. Certainly, Lord Justices Morbick and Reimer did not refer to any principle of interpretation specific to expropriation clauses and had no difficulty in holding that the clause meant what it said. That's all I want to say in reply on ground one. Moving on then to ground two, my learned friend developed for the first time in his submissions this notion that whether a breach is remediable is a value judgment to be made by the judge at trial, with which this court should not likely interfere. Now, he took that from Telcadder at paragraph 31, and I invite the court just to look again at that. That's on page 440 of the authorities bundle. What Lord Wilson says there at letter B is that in relation to a breach of a covenant against antisocial behaviour, there's no escape from the conclusion that the inquiry requires a value judgment.
Sorry,
on
I've lost you.
page 440 of the authorities bundle,
Yep.
paragraph 31, letter B.
Oh, I see.
And I'm reading from the fourth line of paragraph 31.
We're on a different page, 441 in our bundles.
Yeah.
I'm so sorry. Yes,
Don't worry.
I've been deceived by the PDF counter,
Yeah,
which was
sorry.
still on the earlier
It's right
page.
one
It is
page.
441. I apologise. Anyway, I hope the court now has the relevant passage.
Yes.
In relation to a breach of covenant against antisocial behaviour, there is no escape from the conclusion that the inquiry requires a value judgment on the part first of the covenantee and then of the court in determining whether the requirements of section 146, or as the case may be, the paragraph 4 term, have been satisfied. So, first point to make is that is a context-specific observation, and one can imagine that when one is judging rather nebulous forms of antisocial behaviour, the question of value judgment becomes important. It's also worth observing at the end of that paragraph, Lord Wilson says, obviously there would have been a risk that the circuit judge would either have disagreed with Wickland about the irremediability of the breach or have declined to consider it reasonable for the agreement to be terminated. That seems to offer relatively little leeway to the original decision maker and raises the prospect of a superior decision maker disagreeing. And in my submission, this appeal requires your lordships and your ladyship to consider whether they agree with the judge at first instance as to whether these breaches were remediable. There's no real value judgment required. If the court disagrees with the judge below, then it should allow the appeal. But in any event, on value judgment, even if I'm wrong in that submission, of course the value judgment has to be made on the right view of the law and having regard to the right matters of relevance. And that's where we say the judge fell into error. And I'll come back to this in the context of my reply on ground 6. But in short, and I think the court has my point, the judge focused only on the question of whether there was a way of returning the shares, and in fact excluded other factors which we say he should have included, such as the state of mind of the breaching party, the impact of the breach on the innocent party, and the sheer gravity of the breaches, which I accept may be a way of rolling up the first two points. And in addition to that criticism of the judge's approaches to the breaches collectively, we also say that there are problems with remediability of the individual breaches, which I developed in my submissions and will come back to briefly when I reply on ground 6. That's all I want to say in relation to ground 2. Moving on to ground 4, my learned friend, as anticipated, directed his fire both at relevance and correctness. In the context of relevance, he didn't say anything about the remediability of the B shares breach. And as I was prompted by my learned junior to say at the end of my submissions yesterday, ground 4 may have some relevance there, because if Mr. Kulkarni is to be treated, as we say he is, as the owner of 1,652 A shares, then that affects what remediability looks like, particularly in the context of the B shares. Again, I'll come back to this in the context of ground 6. My learned friend then took what I think can fairly be described as a couple of pleading points against me, or perhaps one pleading point. It was said that in the pleadings, at least, the question of Estoppel was directed towards the issue of whether Mr. Kulkarni had to pay for his shares. I don't really accept that that's a fair reading of the particulars of claim. But even if it is, at trial, the point was put squarely as it's put in this court, and for the reasons that it's put in this court, and no pleading point was taken there. In my submission, it would be wrong for any pleading point to be allowed to be taken here. And there's one final point on that, and it does require me to take the court back to Reeve and McDonough, which is at page 506 of the authorities bundle, and it arises from paragraph 58. Which is another aspect of the law on estoppel by deed, or contractual estoppel. As Mrs. Justice Joanna Smith observed, paragraph 58, this is at page 519 of the authorities bundle.
And paragraph
58.
Thank you.
Neither party drew my attention to the fact that the operation of an estoppel by deed is limited to actions founded on the deed, because the agreement of the parties made by assent to the relevant recital is interpreted as agreement to admit the proposition recited only for the purposes of the deed and the transaction effected thereby. And I just rely on that passage to support the way in which the point was put in the court below and in this court. We're using estoppel by deed entirely for the right reasons, namely that for the purposes of this transaction, the SHA, it colours the parties' obligations and the question of what remediability looks like. There were other documents before the court below, not before this court, that made it clear that Mr. Kulkarni, or payment was expected, at least by Newco, before issues of shares could take place. The argument in the court below was really as between Gwent and Mr. Kulkarni as to who was to make that payment, either him or Gwent on his behalf. So that's all I want to say in reply about ground 4. In relation to ground 5, my learned friend's first point is that I'm wrong to say that the judge didn't consider the underlying social relationship, and I want to be clear what I mean when I say he didn't consider it. He obviously refers to it in his judgment, but he refers to it only to exclude its relevance. And that's where we say the error of law took place. That's paragraphs 436 to 437 of his judgment at page 151 of the core bundle. There are then again a couple of what I hope I can fairly describe as pleading points taken against me. I have referred to parties in the grounds of appeal. It's probably right to say that that was a word used in a non-technical rather than technical sense. Perhaps protagonists would have been a better word. But at any rate, specific reference is made to David Lewis, and in my submission, there's nothing in that point. It's also then said that I've abandoned the quasi-partnership case, and to a point that's right. Quasi-partnership, on my understanding at any rate, is something of a term of art used in the context of Section 994 petitions, where it's said that the express terms of an agreement may be coloured or moderated by considerations arising from the personal relationship between the parties. Now, the situation here is different. I say simply that the social relationship is an important aspect of the factual matrix against which this SHA should be construed. In my submission, that's an entirely legitimate and indeed correct way to deploy that aspect of the factual background. Then, in terms of the term, whose interpretation I say the relationship affects, it's quite simply clause 7.1d, and I hope the court has that point. It's the words capable of remedy. What might be capable of remedy in, as it were, a purely commercial context between two parties with no underlying relationship may be different from what is capable of remedy in relation to an agreement between parties who enjoyed such a relationship. My last point in relation to ground 5 is that my learned friend overplays, as the judge did, what he describes as the purely commercial element of this agreement. The personal relationship, as I submitted yesterday, does matter. Shareholders have to meet, they have to pass resolutions, they have to appoint to trust one another. And those were aspects of the relationship between Gwent and Mr. Kulkarni, which were irreparably damaged by the breaches with which we're concerned in this case. Moving on then to ground 6. In this context, the value judgment point again surfaced, and I've made my submissions in relation to that in the context of ground 2, and I don't propose to repeat them. My learned friend accused me of going against the judge's finding of fact by reference to what I described as a sustained attempt to relieve Mr. Kulkarni of his shareholding. I don't accept that I've gone against the judge's findings of fact. Indeed, I say that that is an entirely fair way to describe what happened between June the 21st, 2020, and a couple of months later, August the 21st, when the wrongful allotments took place. There were repeated efforts to persuade Mr. Kulkarni to sign an SHO1 transferring his existing shareholding. What I don't go behind is the judge's finding that those were not motivated by personal animus. It was not a personal campaign based on a dislike of Mr. Kulkarni. The judge held, and I respect that this was a purely commercial approach being taken by Mr. Lewis, Andrew Lewis, albeit a misguided one. But it is still fairly described as a sustained attempt to relieve Mr. Kulkarni of his shareholding. In terms of remediability, I've touched on my submissions in relation to this as well. The apotheosis, as I said yesterday, of the judge's approach is paragraph 455 of his judgment at page 154 of the core bundle. He does, it's correct to say, set out earlier in his judgment at paragraph 435 certain propositions, of which the third is that the more serious the breach, the harder it will be to remedy, but even material breaches are remediable. But when he comes to apply that at paragraph 455, he focuses entirely on the practicalities of the return of the shares, thus equating what happened, as I said yesterday, to the situation where there was perhaps an administrative error by which the shares were wrongly registered to Gwent as opposed to Mr. Kulkarni. So, insofar as he took into account seriousness, it is a fair reading of the judgment in my submission to say that he was simply focused on the seriousness of the removal of the shares and how that could be redressed as a matter of practicality without looking at any of the deeper impacts on the relationship which, in my submission, served to make these breaches irremediable. That's all I want to say about the approach to the breaches collectively. Just making a couple of observations about the remediability of the individual breaches. My learned friend attributed to me the position that the only thing that rendered the A shares breach irremediable was the fact that it could not be achieved within 10 days. Well, of course, I say all the breaches were irremediable for the wider reasons that I've developed at length. But even if I'm wrong about that, the question arises, was the A shares breach capable of remedy as that term is used in the Shareholders Agreement, purely as the judge saw it as a practical matter? And I say the answer to that is no, and I'd just like to take the court to a couple of documents just to make that position good and to correct something my learned friend said in his submissions. If we could go first of all to page 316 of the supplemental bundle. This is the letter from sorry, lost my page. This is the letter from Clerk Wilmot of the 24th of September. And it's paragraph 26 that I draw the court's attention to, under the heading Ownership of the A shares. Clerk Wilmot knew, when they wrote this, that the process was likely to take a number of weeks, as indeed it did. My learned friend then said that the chronology was that Gwent responded accepting this course of action on the 27th of September. That's correct. But he then said that the resolution was passed on the 29th of September. That's not correct. The 29th of September was the date when the resolution was circulated to shareholders, and we can see that if we look at page 172 of the same bundle.
Which page?
172 of the supplemental bundle. Yes, I think there's a number of copies of this written resolution, which we can see are dated the 28th of September. That's the circulation date. But then if the court scrolls through these various versions of the document, they'll see, I'm not sure we've got a complete set, but they'll see signatures applied by the various shareholders on various different dates. So, for example, page 179 bears the date of the 6th of October. Page 182, the 5th of October, and so on. They're obviously signed and returned in dribs and drabs. And if we're then looking for the date when the buyback was complete, the best evidence we have of that is page 215. And at the bottom of page 215, the court will find an email from Mr. Denny of Bevan Buckland, I believe a firm of accountants who are assisting with this process. And in the second paragraph of that email, Mr. Denny refers to the A shares and B shares having gone into Treasury on the 26th of October. So the first stage is to get that written resolution. There is a provision of the Companies Act, which I think from memory is section 275, dealing with that. And I think I'm right in saying that the position is that a maximum of 28 days has to be given. I think that the process can be shortened, but that's the default procedure. If I'm afraid we don't have that section, and if I'm wrong, I'll make sure that the court is put right on that point. And my learned junior makes the point that we also have in the bundle the registers 239 of the same bundle. And yes, I'm grateful to him. That records in perhaps a rather more official format. We see on 239 the date of the 26th of October when the buyback was completed in relation to the A shares, and there's a similar document, I think a couple of pages further on, in fact the next page, 240, in relation to the B shares. So yes, it's probably that rather than the email from Mr. Denny, which is the best evidence. So we say even on that narrow view of what constitutes remediation of the A shares breach, if it is a purely practical matter, history shows that it could not have been remedied within 10 business days. And that is an important consideration when the court comes to have regard to what these parties meant by capable of remedy when they allowed 10 business days for that. That's the A shares breach. So far as the B shares breach is concerned, I've made the point yesterday that what remedy looks like there is not simply pretending the allotment never happened, but giving Mr. Kulkarni the opportunity to subscribe for the shares himself. Could that have been done within 10 business days? In my submission, no. The fact of the matter is that the B shares breach has to be seen as a whole. There's an allotment of 2,000 shares to Gwent itself and the 1,235 shares to the other shareholders. And all that was contemplated. Indeed, the allotment to the shareholders is specifically referred to in the Shareholders Agreement. Sorry, the allotment to the consultants is specifically referred to in the Shareholders Agreement at clause 11. But the fact is it creates a muddle, and remedying it becomes very difficult because, of course, when there's an allotment, existing shareholders have to be given, under section 561, which is before the court, an opportunity to subscribe pro rata. So it's quite difficult just after the event to say to Mr. Kulkarni, you can have the 980 shares that you were entitled to, but because by that time, other shareholders in the form of the consultants are on the scene and they have rights themselves. So one can't realistically, although I accept that the re-amended particulars of claim focused on the 2,000 shares that went to Gwent, one can't realistically exclude the consultants from this process. And this was a point made in the re-amended particulars of claim, where reference is made to the 1,235 shares given to the consultants. I don't need, I think, to take the court to that, but the reference is sorry, I should have the reference to hand. Paragraph 89, I'm grateful to Mr. Rowan. On page 199 and following. So the B shares breach, even viewed as a matter of practicality, was not readily capable of remedy, not capable of remedy at all within 10 business days, and therefore not capable of remedy within the meaning of this agreement. Moving on to the termination breach, again, my learned friend attributed to me the assertion that it did not have any impact. Yes, it's correct that we agree with the judge that it didn't have the effect of terminating the shareholders' agreement, but it is still a breach and admitted as a breach, and furthermore a repudiatory breach, and it had a considerable longevity, which I outlined to the court in my submissions yesterday. Was that capable of remedy at the moment of commission? Well, it might certainly be said that had a prompt notice to remedy been issued and Gwent immediately backed down from their position and treated the agreement as subsisting, I can see the argument that that constitutes remedy. My point, and this risks trespassing into ground 7, is that
I thought if they breached, and it was a repudiatory breach, then doing anything they can afterwards to try and persuade the person not to accept it wouldn't work. I thought that was Buckland. So if they've breached it, they've breached. If it's a repudiatory breach, they've made a repudiatory
well,
breach.
my lord, yes,
Have I misunderstood what you said yesterday?
Yes, my lord, I'm grateful. It's obviously, my lord, yes. That has to be my primary position.
Listen carefully to what you said yesterday.
Yes, indeed. So I don't propose to say any more about the termination breach. It was a repudiatory breach and admitted as such, and yes, therefore incapable of remedy. And then finally, the Hussein breach. My learned friend and I disagree as to how that should be characterised. My learned friend says that it's much more akin to the breaches in Shula than it is to the breaches in Force India, for example. If I can just take the court to Shula once again and just draw attention to the specific facts of that case, page 108 of the authorities bundle. The court will recall from the head note that there was a period at the outset of the relationship where no visits took place at all. That breach was waived, but the period that the court were really concerned with appears at 255 letter D. Between January 13th, 1964 and June the 29th, 1964, visits should in total have been 144. The visits were in total 125. So obviously there was some compliance, just less compliance than there should have been, and it was held against that factual background that this was a breach capable of remedy. The Hussein breach is, as I said yesterday, of a qualitatively different nature. Mr. Hussein was simply not permitted to participate in the management of Newco for that 6-month period from May to November 2021, and in those circumstances, we say there is a genie that has escaped from the bottle and cannot be put back because that time can never be, or that period of management can never be recreated. So that's my reply on ground 6, and finally on ground 7. Again, the bad motive point surfaced here, and my answer is the same. I don't have to say that there is bad motive. I just have to say that there is a deliberate continuing breach of contract, and there certainly was that. The second point that's taken against me is that some of the matters which I rely on took place after the issue of proceedings and are therefore irrelevant. I respectfully disagree with that characterization. Breaches are remediable or not at the moment of their commission. They may subsequently become irremediable, even if they are capable of remedy when committed, but one can look at things that happened afterwards as an aid to considering whether they are truly capable of remedy, and there's nothing unprincipled or erroneous about that approach. And finally, it said that Mr. Kulkarni did not ask the board to serve a notice to remedy. And I accept that as a matter of fact, that is correct. But if Mr. Kulkarni took the view, as I say he correctly did, that the breaches were irremediable, he can't be blamed for not asking the board to serve a notice to remedy. It's an entirely consistent and proper course for him to have taken. Just finally on this, and I'm again in danger of repeating submissions I made yesterday, the relevance of deliberate misfeasance by a contract breaker is established by the authorities we looked at yesterday in a variety of different contexts. Swiss Atlantique, first of all, albeit that's in the rather different context of whether a breach can properly be characterised as repudiatory, but also in time order, Phoenix Media, Akichi, Force India, and Telcada. Those are all cases in which the state of mind with which the breach was committed were considered relevant for one reason or another. And the central point is that it is by excluding that consideration and the impact on Mr. Kulkarni, the sheer gravity of the breaches, that the learned judge fell into error on this question. My lords, my lady, if I may just turn my back just to ensure that there's nothing I've missed. My lords, my lady, thank you. I have no further submissions.
Thank you very much, Mr. Crowe.
I don't wish to rise unnecessarily. It's discourteous and usually unnecessary, but there are just two very, very short points I wanted to correct, if that's all right. My learned friend suggested that I developed for the first time on my feet the argument that the decision below involved an evaluation. That is the point we made in paragraph 48.
I'm sorry, this doesn't sound like, it doesn't arise from a new case or whatever, so why should we hear you on this?
It's correcting a point.
I'm sorry if I said that. I accept that point is in the skeleton argument.
I'm grateful. And the only other point is that my own friend suggested I was wrong in saying that the resolution agreeing was passed on the 29th of September. That is in the judgment. And it's in his skeleton. It's the judgment paragraph 303 and it's his skeleton paragraph 105.
We're not going to give judgment here and now. You will receive a draft in the normal way for you to correct our English and typing, but not, of course, to re-argue the case. We'd be grateful if at that stage you would also seek to agree an order dealing with consequential matters. If there are any points on which you don't agree, could we please have brief written submissions, and we would expect to rule on the points in the order that we make. You, I know, will have well in mind the importance attached to the embargo, but I ought to reiterate that given the stress that has been laid on that in recent times. That apart, it only remains to thank you all, those with speaking roles and those without, very much for your assistance with this case. Mr. Rowan has a point for you.
My Lord, it's perhaps convenient to ask this now. My client is funded by, after the event, insurers. Would the court be prepared to tolerate circulation of a draft judgment to the insurers?
I suspect the answer is yes. At the moment, we've had from you, helpfully, a contact list. And my expectation is that, absent a request to go anywhere else, the judgment goes to the people on the contact list and no further. So the short answer is, I'm not averse to the idea, but we would need to have the details of the people and obviously reassurance that the recipients would themselves be aware of the importance of the embargo. So if you send through what you ask us to consent to, then I would anticipate that you will get the consent.
I'm grateful, my Lord.
Thank you very much.
Rise, April